blogs, Facebook, and other double-edged swords, why your company needs a social media and internet usage policy. I'm Jack Torr, Vice President of Air Technology Services. Our company takes care of computer networks in the greater Waukesha, Milwaukee, and South Wisconsin areas. Our focus is on the small and medium-sized technology needs of business. We help businesses as it pertains to the internet and a host of products and other services to protect their networks and their staff from potentially dangerous areas of the internet. In addition, we also help them by being more productive and even aware of knowledge about dangers on the internet. It is my privilege here to allow Lindsay King of Petre Stocking to present this webinar to you. A little bit about Lindsay first. She's a practicing attorney since 2005. She's currently an attorney at Petre Stocking in Milwaukee. She graduated from Marquette University Law School in 2005, and she graduated at the University of Wisconsin-Madison in 2001. She specializes in labor and employment law and litigation. She's a representative for both the employer, management, and the employee. She helps develop companies' handbooks and policies, and she provides day-to-day policy advising. I'd like to welcome Lindsay King.
Good morning, everyone. Thanks for the introduction, Jack. We've got a lot to cover today, so we're going to get started right away. As Jack said, the title is Blogs, Facebook, and Other Double-Edged Swords, Why Your Company Needs a Social Media and Internet Usage Policy. So I have a question for everyone today. Do you deuce? And I'm laughing because it's kind of a silly question. We're going to talk a little bit about that today. Everyone's heard the stories about the employees who have been fired for their postings online. There's a story that's been circulating through the internet over the years about an employee who writes on her first Facebook page, "Oh my God, I hate my job. My boss is such a expletive," insert your choice of expletive. And her boss, she conveniently forgot that she had friended him on Facebook, and so she responds, "If you hate your job so much, don't bother coming in tomorrow." Now, a couple of years ago, people were wondering, can he do that? Can the boss actually do that? Absolutely, they can do that. And that's kind of where the term deuce comes from. Most employers operate under an at-will employment policy, meaning that you can terminate an employee for any time, for any reason. And from the employer's perspective, why should you have to employ someone who is on the internet bad-mouthing you, bad-mouthing your company? And the term deuce actually came from a woman who was working for a company, and she ran a blog on the side. And on her blog, she started on company time and on the company computer writing things about her boss and how much she disliked her boss and how much she hated her job. And she was discovered and terminated. And she actually trademarked the term deuced. And in the industry now, it's used to describe someone who's been fired for their Facebook or their web or their blog posting. So the screen that you see, these are all the icons for familiar social media: blogs, Facebook, LinkedIn, MySpace, although people don't use MySpace as much anymore, Twitter. So what are these and why do they matter? Well, as I said, they're dominating our business conversation these days. It's not just something that teenagers are using anymore. Everyone in business seems to be using social media, or at a very minimum, the internet in their business. And they've found that it really helps to develop and grow their business and get their product, their message, their brand out to other people. But like with many things, there can be simply too much of a good thing. So you need to be cautious as a business in how your employees are using using the internet and using social media to market your business. This is a really large topic, and as I said, we're going to try and cover a lot today, but this isn't certainly going to be able to cover everything. Furthermore, a couple caveats to you. Social media changes on a daily basis. Just 2 days ago, Facebook, for example, launched a whole host of new applications, and they've changed it, and I haven't even had an opportunity to look at all the new changes in Facebook. The way people use Facebook and Twitter and other social media that's developing on a daily basis changes as often as they come up. And the law on these topics also changes, but the law is always, a little bit of a step behind. Social media has got to be developed, people need to start using it, and then a problem needs to arise or a complaint needs to arise out of the use before any litigation ensues, before any decisions are made, and any law follows. So the law is kind of always a step behind in this developing product. So we keep up with the updates, but things continue to change on a daily basis. So it's something you've really got to keep your finger on or have someone monitoring this for you. So today we're going to talk a little bit about some of the common pitfalls for employers who don't have a social media or internet usage policy. We're going to discuss a few of the recent legal developments that are that impact social media and the internet usage policies. And then we're going to highlight some questions for you as business owners and operators that you should be asking yourself when you're either reviewing the plans that you have in place or thinking about developing them because you've never done that before. So just kind of some basics. What is social media? Social media is defined as using web-based technology to turn communication into interactive dialogue. In other words, it's kind of a blending of technology and social interaction. And it's important to note that social media is publicly available, or it can be semi-publicly available, dependent upon the type of social media you're using and how you've set up your application, so to speak. And we'll get into that a little bit more. But the public aspect of it is kind of what makes social media a unique and new form of communication that you need to be more concerned about. So what are some examples of social media? Probably in this day and age, most of you that are attending have heard at least the words Facebook, Twitter, LinkedIn, blogs. These are all formats of social media, and the first three, Facebook, Twitter, and LinkedIn, are all based upon this premise that you create a profile of some sort, and then you friend someone, or you like someone, or you follow someone. It's all very high schooly. There's lots of terms about, do you want to be my friend? Do you want to follow me? Do you like my page? Do you like what I'm doing here? The idea being that you have some control over your content and you have some control over who's seeing it. But if you're not careful, this is the internet, and people can see this if you don't have your proper privacy settings created. So that's something we're going to talk a little bit more about later. Blogs are weblogs. They range in topics. People have them for personal use, for business use, and anyone out there can create them. Unless you have restricted settings, anyone can see them. Anyone can comment on them. Online forums, websites that allow comments. Those are also examples of social media. When CNN runs a big story and they allow comments on it, you can log on and you can put your comments out there. Anytime you do these things, as I mentioned, not only are they public, but they create a permanent record, and that's something important that should be considered when you're thinking about your policies as a business owner or a business operator, is what do you want representing your company as a permanent record? The internet is searchable, and it's forever, so those things are out there. So who's using social media anyways? Well, there, the last statistics posted by Facebook, there are 500 million active Facebook users worldwide. There are 80 million active LinkedIn members. In terms of business settings, in a small business setting, based upon the National Small Business Association Technology Survey that was conducted in 2010, 86% of the small businesses responding indicate that they have a website. 47% say that they use social media for promotion of their business. 44% of those surveyed allow telecommuting, and telecommuting has its own set of applications that need to be used, as well as some concerns that arise out of there. So it's becoming more and more prevalent in this day and age that small businesses are using this. So here's an opportunity for you guys to provide a little input. Does your company have a website? So I'll give you guys just a minute here to respond. Push A for yes and B for no. Looks like just about everyone's responded here. And pretty much as we suspected here, it's about 100% of you have a company website. So there's another question then that I'm going to ask you guys, how many of you have a Facebook or LinkedIn profile? And I'm not going to restrict this to if it's based for your business. This is whether you have a personal or a business, Facebook or LinkedIn profile. Okay. Looks like most of you have gotten your votes in. And it's about 80% are saying yes, they have a Facebook or LinkedIn profile, and about 20% are saying no, they don't. And you know, that's a little bit higher usage than what that survey showed, but it's not surprising to me because, one, you guys are here and you're interested to talk about it, and two, I think that survey took into account small business usage, and I asked, you know, is it personal or small business? And the reason I think that's important is because there really is a blending and a mixing of personal and business usage, and that's something that's very important to you as business owners in terms of what's allowable and what can be helpful to your company, and also what puts your company in potentially some jeopardy. So that's something we're going to go over a little bit further as we continue today. So why do businesses use social media? Some of the most common reasons are to market or to get their brand out there to other people. They want to communicate with their current clients and customers, and they also want to talk to their prospects, their prospective customers and clients that are out there. They're using social media as a way to communicate with their employees and their colleagues. Networking, a really big buzzword, particularly with the economy being how it is. Everyone's trying to network out there, drum up new business, establish new relationships, try and get referrals, and people are using social media as a really helpful and efficient policy or platform on how to do that. But another reason why a lot of people are doing it is because everyone else is doing it. They don't want to get left behind. Hey, I hear everyone's talking about this LinkedIn thing. I better get on that quick. I better make a Facebook page for my company because everyone else does, and I don't want to get left behind. And we're going to talk a little bit more about that, but that's something that you just want to make sure that's not the only reason you're doing it. You need to understand why this can be beneficial to your business, and then again, what are your goals that you're trying to get out of that? Because that's going to really outline the parameters of your social media and internet usage policy. Now, there may still be some of you out there that are saying, not me, no way, I'm not going to get into this. It's way too complicated. It's too much work. You're here to tell me that there are all kinds of problems it can cause to my business, so I don't want to use it. It's an invasion of privacy. You know, Facebook is just for teenagers posting pictures. Why do I want to post pictures of my family? This is my business, and it's not, you know, anyone else's business. And frankly, it's not worth the risks. And I think, you know, I'm in no way an advocate for one social media versus another, but I think that businesses do themselves a disservice if they're not utilizing social media. The numbers show that, you know, there are so many people out there on there, and you're really missing out on connecting with your current clients and customers, connecting with your prospective clients and customers, and missing out on connecting to those networking opportunities that do exist. So it's worth some time to proactively develop these policies, figure out what's helpful for your company, and then utilize this in a way that really can benefit you guys. So let's talk about some of the different ways that employees use social media. And when we're talking about that, you kind of want to start thinking about what constitutes personal use versus what constitutes business use. Those lines really can get blurred a lot, and that's where you need to have some caution. Another question is, what constitutes a personal device versus a business device? Now, that's less of a gray area. Your business devices are obviously the things that your company's paid for, and personal devices are the things that your employees have paid for. But gray areas come in when you allow your employees to take their business devices home. Maybe you have company-issued laptops or smartphones, or maybe you provide some reimbursement for a personal device. So there can be some gray areas there of what's a personal versus a business device. So there are kind of some 4 basic categories of employee usage, and by no means do they fit into these neat categories. Like with a lot of things, there are gray areas and things that cross over, but generally there's personal, non-problematic, or acceptable usage. And then there's personal usage by your employees that becomes problematic, or it's really not acceptable for your company. And then there's the business-related usage that's not problematic, it's acceptable, it's what you want to promote. And then the last one is probably the biggest red flag, the business-related problematic or unacceptable usage. So we're going to talk about all of those right now. So personal, acceptable usage. This is your employees using it to offer their opinions, to communicate with their friends, really kind of benign stuff that you as a business owner don't have a lot of interest in. It's not interfering with their work. They may not even be doing it on a company machine or on company time. They don't discuss or they don't implicate the company in any way. And this is, they're doing it at home or they're doing it at acceptable break time. They might be doing it on their personal smartphone over their lunch hour, or you might say it's okay for you to use your personal computer at work as long as you know, you're getting all of your other work done. Now, generally, this is the type of behavior that companies want to allow because it rewards and it retains responsible employees. You know, for the most part, people as business owners find that their employees are responsible. They'll use common sense. They'll use good judgment. And so to have a policy that just outright forbids any personal usage whatsoever is probably not the way you want to go, although that's always a business decision. Certainly, you're not going to want to, as an employer, tell your employees that on their own time at home, on their own devices, they can't have social media usage. But what you want to be thinking about, when and how is it acceptable to use at work? And that's something that your policy should really outline for them so it's very clear. And it doesn't have to always be specific. You don't have to, you know, dial into certain time frames, but you want to give some parameters of what's allowable or acceptable usage. And then you need to keep in mind when you're developing your policy, when does their behavior start to become company business? And we're going to talk a little bit more about some of those examples in just a couple minutes here, but you need to kind of keep that in mind and define that for your employees. When does what they do on their personal time potentially become company business? Now let's cross over a little bit into the personal, unacceptable, or problematic usage. This is when it's still on a personal behalf. They're not implicating the company in any way, but they're using it to offer opinions or communicate in an unfavorable or unsavory way. They might be using poor language or going to really questionable links or sites. This may have a negative reflection on your company if word gets back that your employees are engaging in this type of behavior. Depending on the amount of usage at work, it could result in a loss of productivity to your company and cost you money. Oftentimes, it's found to be used as a form of office bullying or harassment. They know they can't go and say these things to their coworkers' faces, but they think, well, it's the internet, it's social media, no one's going to see me doing it, so to speak, and so they engage in it in that way. So when you're developing your policy and you're thinking about those things, you need to balance allowing your employees to be themselves with protecting the company reputation. You need to think about what happens if you start to monitor what your employees are doing on a personal basis and you start to discover membership in a protected class. And we're going to further talk about that. But what if you happen to discover that an employee who wasn't quite ready to disclose it to people reveals on social media that she's pregnant? Like, you can't unknow something. You can't unlearn something once you've learned it as a business owner. And you've got to be cautious that you don't use that information that you've learned in an unlawful way. And we're going to talk more about that. And do you really want to get in the business of policing your employees outside of work? Do you want to be spending your time as a business owner monitoring what your employees are doing on a day-to-day basis? You have to balance that with the promotion of your company and the protection of your company. Let's talk a little bit more now about business-related, non-problematic usage, acceptable usage. This is when your employees are promoting your company or your brand, and they're getting the word out there, they're marketing for you, they're getting good endorsements for your company, they're networking, they're prospecting. This is the type of usage that probably should be encouraged, and this is what you want to happen as a business owner. This may be something that you're actually assigning people. There are companies now, larger companies, that actually have social media personnel, and their sole job is to run the social media for their company. Or, this is a component of an advertising or marketing person's job now. Or it may be something that it's an encouraged activity. You're telling your employees, when you're lacking things to do and you should be prospecting or connecting with clients, utilize social media as a way to do that rather than just doing cold calling or lunches. You may be encouraging them to use your company logos to provide links to supporting companies or affiliate marketers. So you need to lay out some guidelines, though, when your employees are doing this. Does it follow all of your company guidelines in terms of proper communication with clients, rules of engagement? Are there certain professional guidelines that you need to adhere to? And have your employees been properly schooled on that and taught how to do that? Does it provide all the proper disclosures? It's something we're going to talk a little further about as we get into one of the areas of law that this touches upon. But there are several disclosures that need to be made out there. And so you need to make sure that when your employees are marketing on behalf of your company, they're giving the necessary disclosures. Are you properly compensating your employees for this time? Are you encouraging them to do this, and they might be doing it after hours on their own time, and this may introduce some wage and hour issues? Those are all considerations when you're encouraging business use. Now, when does it become problematic from a business standpoint? Well, when your employees are posting inaccurate or misleading information, something that could be a problem. When it's harmful to your reputation because they're disparaging your company or they're engaging in very offensive behavior as an employee on the internet on behalf of your business. As I said, if they're using it to engage in the harassment of coworkers, that becomes your business as a business owner. When it runs afoul of professional rules. In addition to some of the legal areas that we're going to talk about today, there are also some excuse me, professional rules that run with different occupations. An example would be in the medical industry. People in the medical fields really need to worry about HIPAA compliance. And there's a story about a group of nurses who were at an office party, and they just took some pictures of themselves at an office party in the clinic and posted it on Facebook. Well, they happened to do it in a patient's room, where the patient was a fairly high-profile patient, and his name was posted on the chart boards behind there. And anyone who looked at this could see, this patient. That was a major violation of HIPAA, and these nurses got in quite a bit of trouble. And the employer, frankly, got in trouble. And as I mentioned before, you have to remember that all of these things create a permanent record. They don't just go away. You can't just sweep them under the rug. Anyone who wants to can search this and find this information out. So you've got to talk about what's going to be tolerated from a company perspective. And when an employee slips up, what discipline are you prepared to administer? But before you do those things, you need to ask yourself, have you properly educated your employees on what is acceptable usage? Do they have notice that, of what the acceptable policies are? And if they run afoul of those, do they have notice of what could happen to them? Now, you're not going to come away today thinking that there's a standard policy. Every ideal policy needs to address your individual company. You need to think about the protection of your company, the protection of your employees. You want to balance that with promoting your company. This is the whole reason you're doing it, is because you think that something can be gained from this on behalf of your business. And your policy needs to provide the proper notices and disclosures that are appropriate for your industry, for your business, for your usage. Your policy that you're going to craft or revise is going to think about who does the policy actually apply to. Sometimes the policy is a uniform application to every single member in the company. Sometimes there are roles in the company where you say, social media really should not be a part of this person's job. And so the social media policies that I have in terms of business promotion really don't apply to some of my workers. So you need to kind of think about that. And if they don't need to apply to everyone, you need to make that clear. You need to think about what action management or the employer is prepared to take when it's violated. It's great to have these policies in place, but if you're not prepared to actually follow through and take action, then you're really doing yourself a disservice. And so what I often tell my business clients is think about your best employee and your worst employee. Are you prepared to hand out the same measure of discipline to both of them? And if you aren't, then that's not the right measure of discipline for your company, because you have to uniformly apply them when the circumstances are the same. So when you're doing that, your policy also wants to allow management some flexibility and some judgment in what constitutes a violation, what runs afoul. You don't want to write things so rigidly and tight such that if something transpires and it doesn't fit into a certain list or category, you're stuck and you can't take action. So give yourself some options and some flexibility to make some judgment calls or Sorry about that, everyone. Hopefully, unfortunately with this platform, I don't have a way of knowing exactly what happened, but hopefully we didn't get caught off too badly. So what I was saying was there's studies have shown up to a 40% loss in productivity due to excessive time online. And obviously, as a business owner, that's something that you want to combat against. And that's kind of going back to that area we were talking about. What is and is not acceptable usage at work, whether it's for personal or business time or business uses. Also keep in mind if you say, well, I'll just restrict my employees from doing it at all. There have been studies that have shown surfing the internet at work can actually boost productivity when used in a appropriate manner and used in a reasonable fashion. Employees actually, derive some benefit from some short little mental breaks, and social media is a quick, easy way to do that. And again, if that's the way your employees are using that, you want to promote that, you want to encourage that, and reward those who are following your policy and actually helping your business and doing some small personal items on, in acceptable amounts. So ways to address these productivity concerns. Well, your policy should outline or define what acceptable usage is. If appropriate, you should specify when and where internet usage is allowable. You may say that personal usage is only to be used on break time or lunch hours. That may be what's best for your business. You may feel that you can give your employees a little greater leash and say it's kind of at their discretion, provided it doesn't interfere with their business. You want to warn employees about forbidden sites, the big ones obviously being pornographic sites. Most companies tend to restrict online gambling. There may be certain websites that you outright want to forbid because they're too dangerous for your company, or you really don't see a benefit. Some companies do outright restrict Facebook from being active because they say, I really don't think in our business Facebook can be used to promote us in any way, and it's just a waste of time for employees. And that's an individual business consideration that has to be made. But those are things that need to be outlined and disclosed to your employees so they know. And then you need to be setting limitations for personal devices. You can obviously have a greater degree of control over equipment that your company owns, the computers, the desktops and laptops your employees are using, the phones that you provide them with. But in this day and age, most people have a cell phone or a smartphone or their own laptop or an iPad or something like that. And you want to make sure that you are there. While you won't be able to necessarily take control of that device there, you can set limits on when it's acceptable to use those, and to an extent you can also restrict a little bit their usage in terms of the applications. A big example is cell phones that are enabled with cameras, which a lot are. In any sort of environment where there are changing facilities, you absolutely as an employer can and should be protecting your employees, your customers from the usage of picture-taking capability phones, in those settings where there's a possibility that someone's going to be changing. They should be forbidden from use in the bathroom, those types of things. So those are things that your policy should be outlining. Okay, next area of law that social media and the internet tends to touch upon is the Fair Labor Standards Act. So just, it's a large act, but the basics are you need to be, as an employer, paying at least minimum wage for all hours worked for the first 40 hours in a work week. You need to be paying overtime for hours greater than 40 hours. And then you need to be complying with all the child labor laws, which have a whole different host of issues in terms of break time, allowable hours for working seasonal work. And you have to keep in mind that Fair Labor Standards Act applies to non-exempt employees. It generally does not apply to personnel, professional employees, management employees, supervisors, but that's an individual concern, and if you have questions about that, you're going to need to talk to respond to emails at certain hours of the day, and they're non-exempt employees. company-issued electronic devices can create an expectation that your employees always be prepared to answer, and it can actually create a continuous workday. Well, what's a continuous workday? Here's a bit of a case study for you. There was a medium-sized construction company out there, and their foremen were provided with laptops and cell phones by the company. And they were required, before going to the job site, to check in from home with headquarters prior to the workday, and then provide progress reports at the end of the day. And they ended up filing a class action claim for unpaid wages. They said they weren't paid enough. So the question is, did the company-issued devices, those cell phones and these laptops, create a continuous workday? I'm going to poll you guys here. Give you guys just a minute to Okay, I think most of you have gotten your votes in, and 71% of you said yes, I think that happened, and 29% of you said no, that did not create a continuous workday. Well, a continuous workday is defined as the period of between the commencement and the completion on the same workday of an employee's principal activity or activities. So in our example, their principal activity or activities included, for these foremen, checking in with their company before they went to the job site and checking in afterwards and creating these progress reports. Now, ordinarily, under the Fair Labor Standards Act, your commute time to and from work is not compensable time. So, you know, the commute to their job sites ordinarily were not. But now, because they've been asked to do these things before the start and the end of their time on the job site, their commute now became a compensable amount of time, as did their required check-in times and these progress reports afterwards. So as a result, these foremen had been working significant overtime, and so they were obliged to pay overtime payments. There were fines associated with it because they were late in paying those wages since they didn't do it initially. There were attorney's fees involved, and then the company obviously had tax consequences, not to mention the loss of time that they had and their own attorney's fees in resolving this matter. So just goes to show, you know, an example of needing to make sure that you're cautious about when you have these company-issued devices, what the rules are in terms of using it after hours, and if they're expected to do it, you know, are you compliant with the wage and hour laws? So what do? Your policies should be defining what is and is not to be done after hours. If you're concerned about this, you need to be setting limits on responses to emails and phone calls after hours. Let your employees know, you know, you're to do your office-related work in the office, and if we allow you to take your personal device home, you know, it's to be used for personal usage, and you define what amount of personal usage is. But if you don't want them using it for business usages, you need to let them know that as well. You need to provide notice to employees of the consequences of violating these policies. Okay, next area of law that social media and internet usage can impact is the National Labor Relations Act. Now, the National Labor Relations Act protects non-union and union employees against discrimination based upon union-related activity or group action, which is can be defined as protected concerted activity. And protected concerted activity includes discussing the terms and conditions of employment with coworkers. So this is the case study I'll tell you guys about. And you may have heard about this. It's a fairly recent news story. It's the paramedic who was fired for her Facebook posting. So the company fired an employee. She made some critical comments about her supervisor on her personal Facebook page. She actually did it on her home computer on her own time, but she was saying some generally kind of insulting and disparaging things. And she was a paramedic, and she said, "I can't believe I work for a company where my supervisor is a 17, and a 17 refers to a psychotic or a mental patient." And she was terminated. And going back to that earlier example, you guys are probably saying, well, that's fine. She was insulting her company. Well, the National Labor Relations Board, who kind of governs this national National Labor Relations Act, actually filed a complaint against the employer. And they're arguing that her Facebook posting was protected concerted activity, and it was something she was allowed to do. There's a lot that has to be ruled out on this case. So I don't want you guys to panic about this and say, well, wait a second, you just told me that I could terminate employees for this. But it is a good cautionary tale that you need to be careful in terms of making these rash decisions. And that's why we go back to, making a policy that allows for some flexibility and some responsibility to be taken by management to evaluate these situations on a case-by-case basis of what's allowable usage. And this, while this case law is developing, you may have to kind of be in touch with your legal counsel of choice in terms of what's allowable, what's not allowable. But the argument the National Labor Relations Board made is that by using Facebook, she was engaging in a dialogue, a discussion with her employees. And they're saying this is really no different than her talking about the terms and conditions of her employment with her coworkers at the water cooler or in the break room or something like that. Now, there's going to be a lot of dissent from the employer's side that is in no way the same, and she wasn't talking about terms and conditions. All she's doing was insulting her boss, and it's not a dialogue. She was kind of putting it out there on social media, and we'll see how this whole thing shakes out. The first round, so to speak, will be decided in late January, but expect that this is going to be kind of a hot issue for a while. So in the meantime, what should your policy do? Well, first of all, any harassment policies that you already have in place or you should have in place need to carry over to after-hours activities. Harassment of your coworkers doesn't end when the workday ends, and policies should be notifying people of that. If your company considers an employee to be a representative of the company after hours, if you think the conduct of your employees is company business because of the way they carry themselves, maybe they're frequently in company gear or company apparel, they need to be notified of that so that they know that their behavior is subject to some scrutiny. You need to notify them of possible disciplinary measures that they could be faced with if they're running afoul of it or violating these policies. And then while this is pending, and as a good idea in general, you should be letting your employees know that in no way does your policy prohibit lawful discussions. And again, that goes back to that flexibility that we were talking about. You're not eliminating their ability to engage in this protected concerted activity. You're not allowing them to, or forbidding them from doing anything that's lawful. So the policies have those disclaimers, and then again, that gives you the flexibility to go back and talk to your coworkers, talk to your colleagues, talk to other people in your industry, talk to your attorneys and say, what do you think about this issue? Where should I come down on it? Okay. Next area of law that social media and internet usage can touch upon is the Stored Communications Act. And this is kind of a huge body of law, but in terms of what's important to you today, it prohibits the unauthorized access of electronic communication that's stored in a system. So specifically, computers, things stored on the internet. Examples of this violations of the Act would include, hacking into someone's email, but also would include posing as someone else or creating a dummy account or pretending you're someone else in order to get access to your employees' social media personnel or profiles. Something you need to think about is, what about temporary internet files from personal email accounts? A lot of computers and the way your systems are set up have the ability to actually store screenshots. So let's say you have an employee and they're using their personal Gmail or Yahoo account at work, and they're doing it well within all of the confines that you've set out. They're doing it only on their break time. It's not affecting their work. It's really kind of benign communication. And so your employees do this, and they assume, I log in and out. I'm not violating policies. This is my business. And they don't know that their information is actually being stored on the computer and can be pulled up by you as the employer at any time, with the proper tools. You could do this. So in this case study, there was there's a couple of cases out there actually that the same situation has happened. So the employee has been, for example, building a case against the employer. They're thinking about leaving. They're documenting things, and so they're sending emails back and forth to their attorney. They're using a personal password-protected email account. And again, let's just assume for all of these examples, they're doing it well within the confines of the policy. They're not, abusing the email system. They're doing it on allowable break times. It's not affecting their work. And the employee assumes because it's attorney-client communication, it's privileged, it's protected, and then the employee is fired or they leave the position, and then the employer later, who had access to this, pulls up and sees all this communication with the attorney-client emails. So did the employee waive the attorney-client privilege by using the business-issued computers? And I didn't do a poll question for you guys on this. Actually, courts have ruled both ways. It all depends upon the type of notice that's been given through the policy. And in some situations, the courts have said, look, the notice that you gave to your employees simply was not sufficient to let them know that they would have waived this attorney-client privilege, and you are not allowed to use these emails. There was one case where the company was so sure they're right, even after the court came down and said, no, the attorney-client privilege was not waived, they continued to use them, and they got huge sanctions from the court for violating a court order and continuing to use this information. But there have been cases that have come down the other way where the courts have said, look, the policy was very clear. There was no expectation of privacy for the employee when they were engaging in their communication, and it doesn't matter if they were talking to their friend, to their mom, to their attorney. They were using a company device, and so the company has the right to see any of those emails at any time. So, you'll have to think about what does your policy, what's the best thing for your company, and what should your policy say? You need to be providing your notice to your employees that there's no expectation of privacy when they're engaging in personal communication on a business device. You should, if you want to have access to this information, you want to be able to use it, you should be expanding it to include the notice to let people know there's stored information that can be accessed. You have to be careful not to overreach to personal devices. You're likely not going to be able to say, hey, and by the way, if you use your cell phone at work, I can take it from you at any time and look at everything you've been doing on there. Like I said, you've got to address what's appropriate and what's allowable to do, and you handle the personal device in another way. What are the parameters of acceptable usage on their time? And you monitor your employees if you are concerned that that's being violated. And while you're in the process of developing these notices in terms of privacy and internet usage and email policies, you should also be addressing retention and destruction policy of electronic information. Electronic information is a big issue. There's been some recent developments in Wisconsin about what you are obliged to produce when you're in a lawsuit in terms of electronic discovery, and companies are actually getting in trouble because they're destroying documents when employees are leaving companies, and then it turns out that they're later involved in litigation, the employee's suing them, and they say, well, we destroyed all those documents. And they didn't have a policy in place that says, we destroy documents or electronic records every year or 2 years or whatever it is. And the courts really frown upon that and are actually coming down harder and sanctioning people, saying, if you're destroying stuff, when there's the possibility that you're going to get sued, you can really get in some trouble here. So again, this is an example of being proactive rather than reactive. Address what your company's policies are for how long you need to retain and store this electronic information. Give notice of that and then actually follow those policies. Okay, almost to the end of our time here and almost to the end of the different areas of law that this touches upon. The Federal Trade Commission, everyone's probably heard of that. And one of the big overarching goals as it applies to you guys as business owners is the Federal Trade Commission really promotes consumer protection. It's trying to avoid unlawful or unfair competition. And one of the things it does in terms of social media and internet usage is it requires the disclosure of all material connections. So what does that mean? Any employee who's commenting on a public forum about an employer product needs to let the readers know, I'm a representative of my company here. I'm endorsing that, because that's going to affect what they're saying. That's not to say that they're being dishonest, but if you are, as an employee, endorsing an employer product, that may be a different perspective than just an individual endorsement. Likewise, colleagues, business, networking partners, anyone who engages in what's known as affiliate marketing must disclose the relationship. And that's particularly important when there's any exchange of any goods or values. So if you have a partnership as a business owner with another business owner, and you say, for any referral you pass me or any endorsement that you give that results in a referral, I'll give you a 10% discount. You need to be disclosing those relationships in your marketing that you're doing. Another example is, the college student who's a video game wizard, and he writes a blog about his, this happened on this video game kind of thing. And the company that produces this video game catches wind of this and starts sending this guy advanced copies of it and says, try this one out, write about it. Well, he's got to disclose that he received these goods now, because his viewpoint might be a little skewed. It's not going to be this perspective from someone who's not getting something out of it. So anyone who engages in this affiliate marketing, as it's termed, needs to disclose this relationship. So your company policy needs to provide notices of all the disclosures that they need to be providing, and those are going to be company-specific, business-specific, industry-specific. You need to give examples of when disclosures are required so your employees understand fully. Sometimes the endorsement is not such that it crosses the line of an employer-employee or an affiliate marketing type of situation. And so give examples so your employees understand it. And then, give a sample disclosure, or frankly, just give them the language of the disclosure they need to use. Because then as the business owner, you have no concerns as to whether or not the usage is proper. Okay. The final area that we're going to discuss briefly today is this protected status that I referred to earlier, and that's going into, again, kind of the discrimination and harassment areas. So WFEA, Wisconsin Fair Employment Act. You can see there's a whole list of things. You're prohibited from discriminating in employment due to age, ancestry, arrest record, color, conviction record, creed, disability, genetic testing, honesty testing, marital status, military status, national origin, pregnancy or childbirth, race, sex, sexual orientation, use or non-use of lawful products off the employer's premises during non-working hours. All of those things. You can't make hiring decisions based upon those factors. You can't make termination decisions based upon those factors. And you can't make decisions within the term of employment, about whether or not someone's going to be promoted or demoted based upon those factors. That's just in Wisconsin. There are federal counterparts that basically cover all of these: the Americans with Disabilities Act, the Title VII of the Civil Rights Act, the Pregnancy Discrimination Act, the Equal Pay Act, the Age Discrimination Act, the Genetic Testing Act. All of those things are the federal counterparts to these Wisconsin laws. And then mixed in there, you also have all of these anti-harassment policies. You also can't be harassing or allowing employees to harass other employees because of any of these protected statuses. So what does this have to do with social media? First of all, this is important for any employers who use the internet or social media in the hiring process. As we talked about before, you can't unlearn something. You can't unknow something. So if you learn something and you end up learning someone was in this protected class, is that in the back of your mind playing into one of your decisions? So you have to be careful there. Same thing goes for using social media to monitor your employees after hours. What if you discover something that you really didn't, as a business owner, want to know, and now you know it, and you can't unknow it? An example of how that might affect you is, let's say, you're kind of monitoring the stuff, and we'll use the example again of the pregnancy that you discovered by looking at your one of your employees' Facebook pages. And she hasn't revealed it yet to the office, and layoffs are just around the corner, and in the back of your mind you're thinking, hey, she's going to need to be off anyway, and I bet she's not going to want to come back to work. It probably will just be easier if I pick her. Now, did you make that decision because she was pregnant? You've discovered something, a membership of a protected class there, and you can really get into a lot of trouble if that's the basis for your decision and the employee brings a suit against you. What about if you receive reports regarding employees' social media or internet content? You're not doing it on your own, but you're learning this through your employees. They're coming back and they're telling you about this going on. Again, can't unknow the information. So you need to have anti-harassment policies. Any kind of harassment that's going on of your employees after hours. As I said, harassment of employees continues after hours, and so that's something as an employer you have the right to restrict and forbid. And if that's going on, you need to know about that. So your policy needs to provide proper notices of fair employment and harassment policies. Those should be created anyways. then you need to just give your employees notice that these policies apply in any of their internet and their social media conduct. So there's a carryover there. Just because you're on the internet doesn't mean you're insulated, or and you know don't have to abide by these policies anymore. Couple of last-minute notes to consider. In the example of using social media to make some management or hiring decisions, one thing you can do to insulate yourself as the employer is perhaps you're not the one actually doing the research on social media. Maybe you have someone else do it and you have them report back and say, look, I don't want to know about any of this protected stuff. I just want to know about things that are going to be really red flags to our business, and that's going to be business specific, and you can take some time to educate the people that are helping you with that. Another thing to consider, what's your company's policy on giving references or endorsements, because that should apply to social media. There are examples of people who get endorsements from their coworkers on LinkedIn or something like that, where their coworkers are saying these are great people, great person, does a great job, always on time, always responsive, and then a little later down the line, that employee ends up being terminated, and they come back and say, well, wait a second, it's a public record. I was a great employee. So does your policy address that? And maybe as an employer, you want to tell people, any within company endorsements need to be approved by management, or maybe we're only going to do neutral endorsements or something like that. You have to balance that with promotion of your business and what's good for employee morale. But those are things that you need to be thinking about to help protect yourself against this type of litigation that can ensue from discrimination or harassment. Because with social media being a permanent record and it being out there for anyone to see, and this high schoolness that I talked about be my friend and things like that, it really subjects you to additional levels of bullying and harassment and things like that that you need to be aware of. So that was a lot of information. I kind of feel like I've been talking nonstop here, but just some kind of final notes that you should think about and take away from today. So social media and internet usage create permanent records. I guess I should have opened by saying social media and internet usage are here to stay. I mean, the usage is only going to go up. So I think that, as business owners, you really need to be aware of that and start thinking about what you're going to allow and what you want to encourage your company to use. But these records are there and they're permanent. There's no single policy that can apply for all businesses. So you need to look at your individual business needs, your individual usages, and start crafting policies that are out there. And just keep in mind that, it's a helpful tool that can be used. You should be using it, but you don't have to. You don't have to be saying yes to every friend request and every request that you like something. If you have concerns, you have a right to take a step back and be a little cautious and think about what's best for your business. And again, I'm in no way an advocate for a particular social media versus another, but you also don't want to shut yourself off and say, I'm just not going to use any of it. I think, the information out there really shows that it can be very beneficial to your business. You just need to take some time to be proactive, address these concerns, think about what's best for your business, and craft these policies. So, we're just about out of time today, and there may have been a few questions that have been addressed today, and I think, in the sake of keeping with our time limits, we're going to look at those after the fact, and to the extent that there are general questions that we can answer, I will, do my best to respond to those. You can always bring questions to me. You can bring questions to Jack. He'd be happy to do that. Air Technologies is a wonderful company. They've been great at hosting this, and they have a number of products. I think Jack is going to just close with just a final thought or two, because I'm kind of stepping on his toes here, but feel free to contact me with questions and let me know if there's anything that I can do for you. And I really appreciate everyone taking the time to do this. And I hope you guys have a great day, and good luck.
Sure, and I just want to say thank you for attending this webinar, and thank you, Lindsay. We apologize for any audio problems you may have experienced. As you know, to err is human, and to really follow up requires a teleconference line. As Lindsay indicated, certainly policies are not something that you pick up at the local retail store. You do need to update your policies from time to time as factors within change or evolve, and certainly do need to educate your employees. Certainly if you have any questions, like Lindsay said, please feel free to email her or I, and we'll see what we can do to provide you satisfactory answers. In addition to that, we will be sending the slide deck and the audio presentation bound together as one after the session has concluded. Again, thank you for your time today, and we hope you have a great rest of the day.